This statutory interpretation case happens against the background of a remarkable incident in the history of Australian industrial relations. The Builders Labourers Federation was one of the most radical, violent, intimidating and bullying unions in Australia. One of its leaders, Norm Gallagher, was jailed for corruption, and this was the opportunity the Hawke Labor government needed to shut the union down. That's how bad they were. A Labor government shut them down. The legislation deregistering the union also deregistered the other related organisations. The idea was to stop the BLF from just renaming itself and continuing business as usual. The BLF Western Australian Division had been formed before the national body. It argued that in consequence there could be no suggestion that it was created to find ways around the BLF registration. The question, however, was whether the Western Australian Division was formed in or in connection with the industry or a part of the industry in or in connection with which the BLF was registered. On the bare words of the statute, the Western Australian Division fell within that definition. It really was formed in connection with the BLF's industry. The lawyer for the Western Australian Division argued that the provision should be read on a purposive basis to exclude predecessor organisations. To make this argument, it was necessary to look at extrinsic material, such as the Minister's second reading speech. This was permissible under Section 15A(b) of the Acts Interpretation Act, which allowed the use of extrinsic material to determine the meaning of the provision when the provision is ambiguous or obscure. The court, however, said that in this case there was nothing ambiguous or obscure about the provision in the BLF legislation. Their Honours said that the section in the Acts Interpretation Act does not permit recourse to the second reading speech for the purpose of departing from the ordinary meaning of the text, unless the meaning of the provision to be construed is ambiguous or obscure or in its ordinary meaning leads to a result that is manifestly absurd or is unreasonable. In our view, neither of those conditions is satisfied in the present case. As a result, the provision permitted the deregistration of the Western Australian BLF. From this case, we learn that Section 15A(b) of the Acts Interpretation Act can only be relied on when the provision is ambiguous, obscure, or leads to an absurd outcome.